Okay, welcome to aligning your assets with your estate plan. When we say estate plan, we don't just mean your trust. We're going to be talking a little bit about how to align with business entities as well, just so you know. And we're going to be talking about why it's important and how to do it. We're going to start by talking about what I call the three dragon classes that we have to deal with. And the first class is administrative dragons, and we're going to talk about what happens when powers of attorney fail, why they fail. We're going to talk about guardianship and probate, and we're not really going to talk about medical documents, but that is part of the administrative process, and that's a little dragon that runs around on the ground, and everybody has to deal with it. Then there are several classes of tax dragons: capital gains taxes, gift, estate, and generation skipping transfer taxes, business entity taxes, a lot to tax dragons. We're not going to deal with them a lot today, but you can't ignore them entirely because they have, when you don't align assets, that can create tax problems. Finally, we're going to deal with the predator and creditor dragons, protecting yourself and protecting what you leave others. And frequently in lawsuits, what I hear is that dragon just came out of nowhere. Well, dragons don't just come out of nowhere. They're there if you know what to look for. So we're going to start. There really are 4 introductions today. And the way we're going to do this, as we finish a section, there's going to be a blank slide. We'll have a few seconds of silence. And the reason for that is each individual part is going to be recorded and will be available on our website eventually. But we're going to start with what happens while you're alive, and we're going to assume that somebody has created a trust, but they haven't gotten the assets transferred in, meaning that they're going to have to rely on powers of attorney by their agents, and that's their plan A. Now, that's really not the best plan. The best plan is to get it all done, but we're going to show you why. In a power of attorney, a principal authorizes an agent to act under a power of attorney. It's an invitation to third parties to let the agent act for the principal. Now, like any invitation, there's 2 things you can do with it. You can accept it or you can reject it. If powers of attorney fail, that raises the question, okay, what's plan B? There are 2 possible plan Bs. But you can say what you want your plan B to be, but what you do with your assets actually determines what your plan B is. Now, for powers of attorney to be effective, you have to get third parties to accept them. And here's some of the reasons that institutions are reluctant to accept powers of attorney. 1, they don't know if the principal is still alive. That power of attorney dies when the principal dies. And if an institution accepts that power of attorney after the death of the principal, they're liable for what happens. Has the principal revoked it, or is it still valid? Sometimes our legislature plays around with these laws and they may make your powers of attorney invalid. But more importantly, if the principal has revoked it, how would the institution know that? The institution may want proof of incapacity, even if your power of attorney says that's not necessary. Remember, that institution is holding your assets. They want to protect you, and they're just trying to protect you when they want to make sure before somebody acts on a power of attorney that there's a real legitimate reason for them to allow you to act. The principal is not at the third party to verify that the power of attorney is good, and the third party was not there when the principal signed it to verify the signature, make sure that they weren't acting under duress, that they knew what was being signed and the importance of it, and that they were competent to sign. Now, when you look at this, you'll suddenly realize it might actually amaze you that powers of attorney ever work. Then finally, was fraud, duress, or forgery involved? Actually, I had a client a few years ago tell me that he signed a power of attorney one time, and he actually thought he was signing permission for his kid to play soccer. Now, that seems crazy to me, but that kind of thing can happen. Now, this is how asset alignment affects a successor trustee. They may need to align the assets with the trust. They're going to have to rely on the power of attorney in all likelihood to do that. We do have some tools we put in the trust that may help, but they don't always work. Managing the assets outside the trust may require court oversight, and it certainly could lead to it. And court is where you don't want to be. You created this trust to avoid going to court. But lack of asset alignment makes administration more complicated. As you're going to see, it can create going to court that can be very complicated. The trustee has to know and apply multiple sets of potentially conflicting rules. Agents play by a set of rules. Trustees play by a set of rules. Institutions play by multiple sets of rules. Executors play by a set of rules. Hey, trust me, those rules are different. The trustee is better off aligning assets to use one set of rules, avoid guardianship, and avoid probate to administer the trust. Now, what is your plan B? Well, guardianship is a plan B. We define that as the court-supervised management of assets for somebody who's legally incompetent. Some people call that living probate. It occurs when a person owns assets in their own name, they become incapacitated, and they're unable to legally sign their name. Well, here's how guardianship works. Guardianship is not the problem. The problem is a person is incapacitated and they're unable to sign necessary documents to manage assets. So guardianship solves that problem by having a judge authorize a substitute signature. Guardianship is sometimes the only solution to the problem. Now, courts will always look for less restrictive alternatives than guardianship, but sometimes they just don't exist. So my question is guardianship the best solution to the problem? Well, guardianship, I tell people it's one of those 12-step programs. Nobody really wants to be in a 12-step program. I looked at these many times over the years. The minimum cost is going to be from $9,500 to $30,000, and even more in some cases. Austin's going to talk about that a little bit. The annual cost, probably $2,500 minimum, but usually it's going to be more. And it seems like a constant stream of surprises that goes on for as long as that incapacitated person, known as the ward, is alive. Guardianship is disastrous for otherwise good estate, business, and asset protection planning.
So guardianship leads to a lot of time spent. In a guardianship, the court is weighing whether they should take away many rights that a person has. And so it's a detailed process and takes a lot of time to build all the evidence that is necessary to have a case where the judge will agree the right should be stripped from the ward and granted to somebody else. It also takes a lot of money. So whenever somebody hires an attorney to get a guardianship put in place, that's only one of the attorneys involved. The court will have to appoint another attorney to represent the interests of the incapacitated person and make sure the guardianship is even necessary. The doctor has to perform an evaluation, and they're going to charge their fees. And there's often a social study that has to be done to evaluate the living conditions of the ward. It can involve a lot of going to court. Oftentimes when a guardianship is necessary, if there's an emergency that arises. So we have to have an initial hearing to get a temporary guardianship put in place. Then we have to go back, oftentimes several months later, for another hearing to determine whether guardianship needs to continue. Guardianship involves a loss of control. The court is going to take away your rights to do anything in your finances. It also involves a loss of dignity. Oftentimes, well, the ward has the right to appear in court and testify to their capacity, And it's the attorney's job to dismantle their capacity in the courtroom in front of their family. It's not a pretty circumstance, and we'd like to avoid it by planning in advance. It also creates major asset protection problems. When a judge gets involved, they have the ability to issue orders to change the way your planning is set up, and also provides a venue for creditors and creditors to show up. They have to be notified that the case has been filed.
And those creditors and creditors do have rights, and their easiest route is to go through the courts in a case that's already out. So we're going to show you a guardianship case. Carl and Myra set up a trust. They have 3 kids, Peter, Paul, and Mary. They have a $500,000 home. Carl has a $500,000 IRA. They have $1.8 million in investments accounts managed in Carl's name, $200,000 in joint bank accounts. Myra is terminally ill. She can't manage assets for herself. Carl has Alzheimer's. Now, they've set up a trust, but the only asset they transferred to that trust is their home. And powers of attorney have failed. And after all I told you about why they might fail, that shouldn't come as a surprise. So what happens? Well, what we need is to get assets to provide for Carl and Myra. They need to be able to sell the house because it's no longer feasible for them to live there. And neither one of them is objecting to that. But no one else has the legal authority to do it. They need funds for Myra to be in a facility, and Carl is better off in a facility, and he's not resisting. But again, somebody has to have the authority to get him there. This process started 4 months ago. So he mentioned that this takes time. Hey, it's not unusual to not even have gotten to a hearing at this point. For the guardianship, we've got to get a doctor's report for Carl, hire an attorney to file a guardianship application, provide notice to the interested parties. And in here, that's the kids, Peter, Paul, and Mary. The judge appoints an attorney ad litem. The court investigator does a background check on Peter because that's who is going to be the proposed guardian. Peter has to undergo approved training as a guardian. Courts may be backlogged on background checks. We saw that under COVID. Courts that normally got these done in a matter of weeks were taking 6, 8, 10 months to get to the background check, which happens very early in the process. And while all of this is going on, no one has access to financial information or assets. Now, until Carl's assets can be accessed, the kids are going to have to pay. They've got to maintain the house. They've got to pay the bills, including medical bills. They've got to provide care of their parents. Peter is going to have a bond. That's going to cost up to 3% of the assets that are part of that guardianship. And in case you didn't do all the math a while ago, that's $2.5 million here. That's up to $75,000 a year for Peter just to have a bond. And he's going to have to pay for this until he can be reimbursed. The judge appoints a court investigator for social study, and then comes the hearing. Now, what leads to guardianship? Well, assets that are individually owned or assets that are jointly owned by 2 people, such as the home. I actually did see a guardianship one time that started because of needed roof repair when the house was in the husband's name and he was incapacitated. And ultimately, the wife trying to get the roof repaired is what led to the guardianship. But on incapacity, we go to the probate court for guardianship of the estate, which is difficult, and or for the person, which is much easier. Now, does this sound like a good plan B? I don't think so. What about the other plan B? That'd be a trust. Now, with a trust, you still got to deal with incapacity. But look at the radically different sets of rules. The assets that are in the trust are managed by the terms of the trust. It replaces the powers of attorney. The trustee holds legal title to the assets. An agent has no authority except as an agent, but an institution cannot refuse to deal with the person who holds legal title to the assets. the assets in the trust, avoid a guardianship. That trust can have incapacity instructions. We do put incapacity instructions in trust, and it's a great idea. It saves the family a lot of trouble. Trusts are easy to manage, easy to change, and easy to update, but they work best when the assets are fully aligned with the trust. So there you have it. Which one is the better plan B? Well, it's the trust, but you're really better off getting that trust funded after you get it in place. Go get the assets aligned. We recommend that you do that as quickly as possible while you're alive and able to do it, so that your kids don't have to deal with what Peter, Paul, and Mary had to go through. Now, what do we mean by align assets with the trust?